2022 CR 3597, State of Texas versus Chardonnay Leanne Lockhart. Can I have parties announced for the record for the state? Defense.
Andrew Frederick, Ms. Lockhart.
Are you Ms. Lockhart?
Yes.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Lockhart, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
I am a female. You keep saying, yes, sir.
No, I said yes, Your Honor.
No, you said, yes, sir.
I said yes, Your Honor.
I would
Okay.
say I heard yes, Your Honor, as well, Judge.
Okay. All right. Are you proceeding on the,
One moment.
are you proceeding on the indictment as presented?
Judge, we're gonna go with the lesser included offense of attempted arson, recklessly causing damage.
Okay. Any objection?
No objection.
All right, I'm going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
All right. Oh, you're right. She did say yes, Your Honor. I don't know why it sounded like sir. My allergies are really, I apologize. My allergies are really acting up today.
And Judge, no, I whispered to her that she needed to speak up and not say it. So yeah, no questions.
Okay, that's okay.
Thank you, Your Honor.
All right, they're charging you as arson as a Class A misdemeanor. The range of punishment for that offense is up to $4,000 fine and up to a year in the Bexar County Jail. Do you understand?
Yes,
right.
Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
If I could answer a little bit more, Your Honor. Yes, I do believe she does. She's mentally competent. She was done a psych evaluation for competency a few months ago. She has been found competent after discussing the case with her today and last week as a jail visit. I agree, she is competent.
All right, so she's already been to the magistrate's court and they've deemed her competent?
That's correct, Your Honor.
All right, do you believe she was sane at the time of the offense?
Yes, Your Honor.
Ms. Lockhart, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
All right, court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Okay, according to the plea, the state is proceeding on the less included offense of attempted arson recklessly causing damage. They're recommending deferred adjudication. They're taking in consideration County Court Cause number 634806, and there's to be a MIC evaluation. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Next, I'm showing you outside the plea bargain agreement. State is recommending that your deferred adjudication be for a term of 2 years and there be a TAP evaluation. Did you understand?
Yes, Your Honor.
Okay. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
All right, then to the offense of attempted arson recklessly causing damage, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offer state exhibit 1 and all attachments.
No objections.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Has to follow the plea bargain.
All right, Ms. Lockhart, if you're released from custody, do you have a place to live?
Yes, Your Honor.
Where?
738 Morris.
No, I'm sorry, don't say the address,
Oh,
but who will you be living with?
I apologize. It's a property my father had bought me.
Sorry, what?
I'll be living by myself.
Well, whose property is it?
My father.
Why were you not living with your father before? During this incident?
No, it's because I'm 30 years old.
Well, no, here's the thing. I'm reading this and it appears, rightly or wrongly, the way I'm reading it, it appears that you were homeless. It says that you started this fire because you were trying to dry a blanket. So I'm wondering why you were not living. Well, no, that's what they say you told them. It's in the police report. So I'm trying to figure out why were you homeless And why would your father let you live with him now?
Judge, if I can just have a second.
Here's the thing, Ms. Lockhart, you need to be honest with me, because I'm trying to figure out your conditions. And let me just tell you, one or two things are going to end up happening. If I don't believe you're going to be honest with me, this is going to be set for a PSI. You're going to be sent back to the Bexar County Jail. They're going to do a PSI report, and I'll get it when I get it, which will probably be within 8 weeks. So you need to answer my questions, and you need to answer my questions honestly. Now, in this police report, basically, it's implying that you were homeless because it said there were clothing and other items, and that you lit this fire because you told them you were trying to dry your blanket. So this is what you stipulated to. I didn't force anybody to stipulate to it. That's what's in the police report. So why were you homeless if now you can live with your father?
I wasn't at home, but I was not homeless.
So why were you living in this field or wherever it was with your items?
I have no idea. I don't know how to answer that.
All right, so why is she wearing yellow today?
I'm pregnant,
Okay, I just wanted to hear it. And how far along?
like 21, 22 weeks now.
Judge, I didn't mean to be presumptuous, but I have been in this court once or twice before. I did tell her she was going to be taking a parenting class, which was theoretically outside, but she understands she's going to take a parenting class going forward. Because that's going to be her.
All right, and is she on medications at the jail?
Yes, Judge, she was not on her medication at the time. Now she is on her medication. She's frankly alive. She's definitely competent at this point in time. At the time, she was not being rational, but at this time, she is going to be successful going forward. There is the part about the mental MIC caseload and her being interviewed for that. I believe that would be necessary. And she understands that being med compliant is going to be a part of that as well.
All right, do you have any other children?
Yes, I do.
How many?
2.
And where are they?
Out of town with my family.
And what are their ages?
11.
They're both 11, twins?
Mhm.
That's either yes or no.
Yes.
All right, this is what, is there anything else from either side? Do you know if she's receiving SSI now?
I don't know.
All right, I'm going to sentence you to 2 years deferred adjudication. I'm going to want felony drug court referral. They should be able to do it because it's 2 years. And I'm going to want a MIC evaluation. Those are to take place while in custody. And then I'm going to want a referral. If she's not approved to MIC, I want a referral to Center for Healthcare Services, parenting classes. Take in consideration County Court Cause number 634806. 80 hours of community service restitution. Once she completes parenting, that will be satisfied. Regular reporting by Zoom or in person. Regular UAs. And I'm going to want a TAP evaluation in custody as well. If TAP recommends inpatient treatment, we'll start her with intensive outpatient treatment. And I'm going to want field visits 1 time per month until further notice. Probation will do proof of employment within 30 days of release, or proof of SSI within 30 days. There's to be no employment as a home health care provider or with minors. And I'm sorry, instead of the regular UA's probation, I'm going to want the UA hotline with testing at least once a week. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court to be successful?
No, Your Honor.
Counsel, do you think there's anything else your client needs?
There's nothing else she needs, Judge. We asked the evaluations be done when she's out in custody.
All right, that will be denied. All right, we can go off the record. Was she not approved for mental health court?
Honestly, can't tell you off the top of my head, Judge, since she's been, in custody this time.
Mhm.
We've conferred with the DA and this is the attempt. She's got quite a bit of time. So this is our agreement that we reached.
All
If
right.
she was approved, I know that she's being evaluated for mental, at the MIC caseload.
Mhm.
Being that it's a misdemeanor, but mental health court, I don't think that was approached because it wasn't an option to be a misdemeanor until we talked about the last week.
All right, probation, can you also do a referral to the mental health court? And see if they'll accept her. My understanding, mental health court, it's sort of like PTD. So if they accept her and she completes it, then this will be as though it never happened. So counsel, if they accept her in PTD and you all want to come back and ask for a motion for a new trial, or withdraw her plea,
Yes.
then the court will consider that.
That's what I was thinking ahead, Judge, and that's why my brain was going like, I don't know if it looked like I was rolling my eyes. But I was like, does that mean that she wants? Yes. Okay.
All
I'll
right,
explain that.
so,
Thank
LaShawn,
you.
if you can, you're welcome. LaShawn, if you can make sure she's referred to mental health court and tell them that even though she's entered a plea here, if they are willing to accept her, defense is going to file a motion for new trial and the court will grant it. All right, thank you. You're welcome. Have a great day. All right, court is calling 2022 CR 3597. I'm sorry, you all need to be silent in the box wearing the record. Ms. Kramer? That's okay. You can ask them to move your client down to the other end. Court is calling 2022 CR 3597, State of Texas versus Chardonnay Leanne Lockhart. Can I have parties announced for the record for the state?
Dan, U.S. Court for the State of Texas.
Defense?
Mark Darling for the defendant.
And are you Ms. Lockhart?
Yes, ma'am.
Going to show you a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
Are you the same Chardonnay Leanne Lockhart who was placed on deferred adjudication in 2022 CR 3597 for the offense of attempted arson, reckless causing damage on May 15, 2023 for a period of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violate condition number 4 in Bexar County, Texas. The defendant, Chardonnay Leanne Lockhart, then and there failed to report to the supervision officer as directed for the months of August and September 2023 in violation of condition number 4.
How do you plead to that? True or not true?
Your Honor, the state waives all the violations.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine? Did you understand that?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is for 272 days in the Bexar County Jail and for this to satisfy the judgment, since it's a Class A misdemeanor.
All right, has she done anything on probation?
No, Your Honor.
All right, then why would, well, all right, so you've done nothing on probation. Probation, what are you requesting?
After she was here last in court, she just did not show up anymore. So we understand that there may have been, or maybe some issues as far as maybe possibly homelessness and so forth. And we were going to ask just to amend for a moral recognition therapy, job skills training, and possibly the reentry center for services.
And will this be set up while she's in custody if I follow this?
We can't set up those things in custody, Judge.
All right, Miss Lockhart, can you raise your right hand for me, please?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Chardonnay Lockhart.
All right,
Chardonnay Leanne Lockhart.
all right. Miss Lockhart, what's the status of the pregnancy?
I'm not pregnant any further.
Okay,
Judge,
I mean, how do you mean?
okay. All right, so here's my issue. I don't know if anybody wants to ask any more questions. But I'm not going to give her 272 days in the Bexar County Jail. If she wants to be revoked, she can be revoked. I'll give her 365 days at the Bexar County Jail. Or she can, or I will follow the probation's recommendation.
You understand? Do you agree? Judge, it's Ms. Lockhart's wish that you do sentence her to 365 days in the Bexar County Jail after revocation versus the alternative, she doesn't wish to make
Right,
those
it'll be a
efforts.
$4,000 fine, and time and money is not going to run concurrent.
Well,
Because let me just tell you, Mr. Lockhart, here's what the problem is. The problem is here is that you're on deferred for an attempted arson. You're homeless. You have no job. You've been staying from hotel to hotel. You're going to end up potentially, if I just send you out in the world, you're going to end up getting another theft case, or something else is going to end up going wrong with your life if you don't get stable. The only thing that I can do other than continue on probation is maxing you out. And the reason why I would max you out is because you have done nothing. And the reason why I will not run time and money concurrent is because you have done nothing. So the choice is yours.
I paid them.
yeah, I'll tell the judge.
Yes, what would you like to do?
Okay, I would like to do the 365 and pay the $4,000 fine.
Court will grant the motion, find you guilty, sentence you to 365 days in the Bexar County Jail, give you credit for any time served. There's a $4,000 fine. Time and money is not to run concurrent. All right, good luck to you.
Thank you.
You're welcome.